Hello, everyone. Welcome to Court with Krissy. Judge Hunter calling this defendant an irresponsible jerk? It's kind of an understatement. The POS was arrested and picked up new charges just a few days before this sentencing. He's getting all the time. Plus, there's more to come. I hope you like it. Court with Krissy is now in session.
Mr. Fragle, is Mr. Stone here ready?
He's incarcerated.
Oh, that's right. Over here shortly. Okay.
I just found it out.
Pardon me?
Since I talked to you, he may have found it. I don't know.
No, I just saw him.
Okay.
Was you charged with that?
Yes, over the weekend.
Hmm?
Yes, over the weekend.
That's Mr. Stone. Yeah, come right up. Stone. Yeah. Mr. Stone, you can go right up with us. Podium, please. Court is on the record and calls a matter of people of the state of Michigan versus Brad Stone. This is file number 25-5438.
Spirit Coke on behalf of the people.
Patrick Fragle on behalf of the defendants.
Sir, you are Brad Daniel Stone.
Yes, sir. Yes, Your Honor.
Mr. Stone, you're here today, lodged next door. Apparently, you had been arrested over the long weekend on weapons and assaultive offenses. You're lodged in Crawford County Jail. I'm noting those things only to describe your appearance, not because it matters to me. It does matter to me, but not necessarily because I'm going to sentence you on those matters. I'm not. I'm going to sentence you on domestic violence aggregate offense. I get a chance to review the report.
Yes, Your Honor.
Mr. Fragle, were you made aware that your client was arrested over the weekend?
Yes, I received a call this morning and appreciate the heads up.
All right, and was it your understanding that the court has it accurate? I said weapons and assaultive offenses. I don't know the exact nature of them. I had my staff ask just so I could be aware of it. She told me, but I only remember that there was weapons offenses and some assaultive offenses. Do you have an idea what the charges are?
I just spoke with the prosecutor. She indicated unlawful imprisonment, which was he and his girlfriend. And if there's any weapons, I believe they're stored in his cabin.
All right, and again, I'm not going to go through the underlying merits of those allegations, other than to the extent that there was an arrest and what the arrest was for. Ms. Koch, is that accurate? What he was arrested for?
Possession of cocaine, unlawful imprisonment, and some other charges that involved weapons. Yes.
Okay, and you were aware of that fact?
Yes, I charged it.
All right, and that's going to be the next question. Whether it was in this county. Ms. Koch, are you ready to proceed to sentencing?
Yes.
Mr. Fragle, do you have any corrections, additions, deletions to the body of the report?
Yes, Your Honor, under credit for time served on page 2 of CFJ 145, he has 6 days credit at this point, and that would be since 11/28 to today.
Was bond hasn't been revoked in this case?
So I believe he's sitting on a bond violation though.
No, I haven't charged any bond violation. It would be my impression that he's sitting on whatever the charges are.
Okay.
Do you have information contrary to that?
No, I don't, Your Honor. I don't know. I kind of assumed it was a bond violation for the weapons.
I was not made aware of his arrest until I arrived this morning. So I didn't even know that he was arrested. And the only way that I knew it is my staff routinely reviews jail records to make sure who's lodged. If it's a client of mine, a client or a defendant rather of mine, then I have to set arraignments. So she reviews those every morning. But that's the only way that we get Mr. Stone is lodged.
Okay. The next would be on page 1 of CFJ 284B, third paragraph, where the defendant was said to have, it says no contact has been made, period. That's the last sentence of that paragraph. We would ask that be stricken. Just and I'll explain why. I was contacted by the agent on October 29th, and as soon as I hung up with him, I picked up my phone, called Mr. Stone, and sent him a text message indicating who he needed to call immediately. And it's my understanding he did make contact, but there were no return phone calls. I myself tried on, I believe, Tuesday, left a message, and it was, as Mr. Stone described, the female's voice on the answering machine, and have yet received a call back myself. So I believe he did attempt, once I nudged him that, hey, this is important, you need to get a hold of him, but there were no return calls.
Mr. McFall, I know this isn't your case, but I assume you've discussed this matter with Mr. Hayden.
Yes, Judge, briefly.
Did Mr. Hayden receive any contact from the defendant?
To that, I don't know.
Well, I don't have any information to suggest that there was any contact made. My view is that the PSI should be treated as accurate unless I've had convincing information the other way. And Mr. Stone's report to you that he contacted Mr. Haven, Mr. Haven has reported in the evaluation and plan that there's been no contact is not convincing to me. especially in light of the fact that as of the time of the writing of the PSI was done entirely based upon another report and not based upon any information that was received by Mr. Haven. So I note your objection to that portion of the evaluation plan, but I believe it to be accurate and I won't change it. Did you have other additions, corrections, or deletions?
Yes, Your Honor, just 2 paragraphs down, just 4 or 5 lines. The defendant indicated this morning that Jackson County sentenced him on November 20th, 2025, as opposed to 12/4 of 25.
That is true, Judge. We confirmed that this morning,
All right.
informed Jackson County probation agent of this arrest here this weekend. So
Any objections to that change?
No.
So court will make those changes then. Any other corrections?
Just think maybe of a Scrivener's error, looking at page 5 of CFJ 284B, entry number 4 and entry number 5 appear to be the same incident.
That is correct. They're going to delete number 5. I spoke to Mr. Haven about that this morning because I asked the same question.
So if I delete 5 of 6, does that satisfy you, Mr. Frager?
Yes, Your Honor.
And all right, so all over that number 5 of 6 is stricken. Anything else to correct?
No, thank you.
Ms. Koch, on behalf of the people, I know that you made a request that Ms. Osborne would appear via Zoom. As you can see, she's here on the screen. Did you have any corrections, additions, or deletions to the body of the report?
No.
Ms. Osborne, welcome. If you could unmute yourself and state your name for the record, please.
Hello, my name is Stacy Osborne.
Thank you. Ms. Osborne, as a victim of this offense, you have a right to be heard. Mr. Frager, do you have any reason to object to or that there should be a Zoom for a victim to that statement?
No, Your Honor.
Ms. Osborne, you're entitled to tell the court anything that you think I should be aware of about how you think I should proceed or what I should know about this offense and how it's affected you.
Okay, I do have something that I typed up, so I'm going to read it. I might have to pause a couple times. I'm a little nervous about it, but so I was involved in I was the victim in the February 16th incident with Mr. Brad Stone. And after nearly 10 years in a relationship with him, I've seen that side of him that I saw that night before. The fear I felt that night was not new, but it was the first time I was able to call 911 and have the courage to stay on the line. The dispatcher and responding state troopers witnessed firsthand the behavior that I had been living with for years. For the first time, I finally felt seen and believed. Testifying in June was really scary. It was terrifying. I feared retaliation and felt overwhelmed by the weight of finally telling the truth publicly instead of keeping it behind closed doors. Seeing the state trooper in the room helped me get through it and confirmed what had happened was real. Even now, I'm still scared of possible consequences that could come from sharing the statement today, which shows how real my fear really is. The weeks following the incident were extremely difficult. I developed noticeable issues with my voice due to strangulation. My neck still makes popping noises, and I have a limited range of motion from injuries sustained during the incidents that night. I was living in fear that I'd somehow be the one charged due to comments that Mr. Stone would make to me. He actually contacted my landlord directly after the incident and arranged an eviction to try to scare me into giving him unsupervised time with our daughter within 1 week of the incident. He told me he would only withdraw the eviction if I complied with his terms. Until the no contact order was issued, he continued to intimidate and manipulate me. Even after he tiptoed the line, posting subtle threats clearly intended to punish me without technically violating the order. His behavior since then has escalated further. The home we had shared as a family once, which is family property on his side. It was on a land contract from his parents. He failed to make payments and was evicted, but retaliated by destroying the house, taking a chainsaw to the back deck supports, bulldozing the pools, and spray painting hateful messages to his family on the walls, including in my children's bedrooms. And Mr. Stone operates with a sense of entitlement and superiority, acting as though rules do not apply to him. This fuels his retaliation and increases my fear because his anger grows whenever he feels challenged or denied control. I remain deeply concerned for my safety and my children's safety and those close to him. This incident has caused significant anxiety, many medical appointments, and missed work. It has changed my life daily and my sense of security. I want to ensure my safety and safety of my children and also anyone involved in his life. I do hope he gets the help he needs to address his anger and behavior issues. thank you for allowing me to share how it affected me.
Thank you, Ms. Osborne. I appreciate hearing your version of what's happened, how it's affected you, and I'll certainly take that into consideration in closing sentence. Ms. Coe, did you have allocution on behalf of the people?
Yeah, so we did this plea with Mr. Stone. He had been 12 years without any criminal history. He did have some incidents in Jackson involving cocaine just recently, but he had only had 2 operating while impaired. He's 42 years old. We talked to the victim about doing the deferral and whether to make it part of the plea. Since then, we've had the incident that happened this weekend. Now, the pretrial release order does not have the boxes checked for no use of alcohol, no use of controlled substances, or no firearms. But he was convicted just recently in Jackson County on the other case. I say this because these dates are all very close in time. But this weekend, when police arrived at the home, he had been into an accident with a person who was on the back. They had that person inside the vehicle. They would not answer the door. Police had to kick down the door. They found firearms in the home. They found cocaine in the home. The female in the home could not walk. Mr. Stone had told her not to speak and would not let her go to the hospital. We had made this deferral part of the plea, so I understand that if the court doesn't go forward with it, he may be allowed to withdraw his plea. But given that he's been completely avoiding contact with Mr. Haven, I spoke to Mr. Haven about that this morning, said he had not spoke to Mr. Stone at all during this. I don't know how he's going to be successful in a deferral, or whether that's even appropriate at this point. I do think a significant jail sentence is appropriate given the facts of this case and his behavior since in terms of not complying with the PSI process. Thank you.
Mr. Prager, on behalf of Mr. Stone.
Your Honor, this is, if what the prosecutor says today, and if what we look at happened at February 16th, and then on April 20th of 2025, and things we may know in between, we do not know in between. The alcohol and drug problem is certainly taking a hook in Mr. Stone. Each of these incidents involves cocaine and drinking, at least according to the prosecutor, this last one. But it's been found to have happened in Jackson County and in this county. And to his merit, he's had no contact with law enforcement. I'm not incorrect, since 2013. So something has changed in his life. And I believe any probationary sentence the court assesses should begin with an order that he enroll in the appropriate inpatient or intensive outpatient counseling for chemicals and alcohol. He's shown himself to be supporting his child, to running a business for 11 years. He employs 3 or 4 people and keeps them actively employed. As we stand here, he has 12 work orders on his shop alone. It's just not something run out of his backyard. He has a storefront, he employs people, and he delivers a good service. So he has a lot of strong points. In fact, again, most importantly, perhaps supporting his child through his business. So he may not even understand what's going on in terms of his life right now, but he needs to do some introspection and have a chance to recover and get a handle on what the substances are doing to him. That being said, I would ask the court to suspend any jail sentence that may be recommended, with the understanding he get a substance abuse evaluation soon, forthwith, and follow those recommendations. The court's inclined to provide jail and decline to issue a deferral under 769.4A. I would then argue the probation is not necessary. He's going to be supervised by Jackson County MDOC Officer Timothy Johnson for approximately 2 years. And those will be very stringent conditions in his home, in his neighborhood, that he can be held accounted for. So that being said, I would ask the court to trust him with a deferral, give him an opportunity, seeing he has had an ability to be stable and sober, and if not, assess a nominal jail sentence and turn him over to Jackson County for supervision. Thank you.
Thank you, Mr. Prager. Mr. Stone, was there anything you wish to tell me before I close sentence today?
Yes, Your Honor. I have made mistakes here. Obviously, that's been shown. I'd like to get my life back together, and the only way I can do that is getting back to business, supporting myself and going through treatment programs. Other than that, I'm gonna lose my house, my family, everything I've worked hard for the last 15 years. So if I could just possibly, go to treatment program, that would help me get back on track here.
Thank you, Mr. Stone. I had a chance to review the sparsely made PSI. And I say sparsely made PSI because it wasn't through any of your efforts that the PSI was done. It was only because you happened to have a recent PSI from a different county for a different felony that I have any background information about you. That's one point that's very important to me. Because as I told you at the time that you entered your plea, it wasn't a request, it was an order that you meet with the Department of Corrections so that it can be done. When you didn't, the agent took extraordinary efforts, contacted your attorney. Your attorney apparently took extraordinary efforts trying to get in contact with you, and you did, in my estimation, nothing. That's the first order of business, is that I don't feel that this PSI does a very good job, at least of giving me all of the information, although it does give me quite a bit of information, and that information that I didn't have, at least in my mind, has now been supplemented extremely by Ms. Osborne today. At the time that I accepted a plea from you, I told you that under 769.48, the domestic violence deferral offense, because that was a potential, if you were not granted that benefit, that I would allow you the opportunity to withdraw your plea. Number one, you are not going to be sentenced under 769.4A. Based upon my reaction to what Ms. Osborne has said, my reaction to what you have said, I'm firmly convinced that you are not a person who is unlikely to commit a domestic violence offense again in the future. And instead, it appears very clear that that is your goal, and that is what is going to happen. And I say that based upon a combination of crediting the testimony and the offer from Ms. Osborne and not believing the little things that you did say. You didn't comment once when you had the opportunity to about this event. You didn't apologize to the victim for the damage that you caused. The damage that you caused to your own children, the custody order has changed because of your actions in assaulting this individual. And I would also note that when you enter a plea and then engage in misconduct, any type of sentencing agreement is to the court, potentially, in my discretion, out of the window. And in this case, this potential sentencing agreement, 76948, is forfeited by you due to multiple layers of misconduct in between the time of the plea and today's sentencing hearing. Number one, the misconduct, as I've already indicated, is you failed completely to meet with the probation agent to get a PSI done. And again, the only reason I have that PSI is because a different county had recently sentenced you on another felonious criminal act. Number two, it's clear to me that while I'm not having a trial on what happened, and I'm not making any factual determination one way or the other, you were arrested and been sitting in jail for the last, for your attorney, 6 or so days on new allegations of felonious activity regarding drugs, assaultive conduct, unlawful imprisonment, and other matters. That's additional misconduct, which results in the forfeiture of any potential sentencing under 769.4A. And it also means that because you engaged in such horrific misconduct, you don't have any ability to withdraw your plea. You're simply going to be sentenced on this case. I hope you were listening to Ms. Osborne. I definitely was. I suspect that if I allowed you to retort, you would, and you'd tell me why things she said are not accurate. But as a sentencing judge, I have to compare what's said between various individuals. And if I were to hear from you retort and respond and deny, I would not find it convincing. Because again, already, when given the opportunity to speak, you did nothing to explain your remorse about how the things you've done have damaged your family unit, have damaged Ms. Osborne. But I particularly credited Ms. Osborne when she told me that she was scared. She was still feeling scared, but she finally feels seen and believed. She still fears retaliation, and according to her, the retaliation has been ongoing even after this case started. You threatened her with making her be evicted, threatened her with needing to have supervised visitation with the children. Behavior has escalated since. You failed to pay the mortgage or the land contract balance. You destroyed the home. You spray painted the house, including your own children's rooms. The actions that you've taken based upon Ms. Osborne's report, which I find incredible and believable, are ridiculous. They paint a picture of an irresponsible jerk who takes advantage of anyone who he can. That is further supported by the background, again, within the PSI. Some of it's not there. The fact that you were just recently arrested, but that again tends to speak volumes to what you're doing. You haven't reported to probation as required. You have other felony offenses that are around the same time in Jackson County. You clearly have a need for treatment, but you also, from Ms. Osborne's reports and from my estimation on the basis of those reports, have a firm need for punishment. Because it doesn't appear that you have any recollection or knowledge of the fact that your actions were criminal and deserve some sort of accounting. And I say that because, again, I have to look at whether or not you're showing remorse for the offenses, not just feeling sorry for whether or not you think you need treatment. And you didn't when given the opportunity to offer a single sentence in that regard. I don't think it makes any sense to put you on probation. Your attorney has it right there in my estimation. You're going to be on probation in Jackson County, and if convicted in this county and other charges that were recently filed, then you'll be on probation perhaps here. But there's no need for you to be on probation for a misdemeanor offense. But given the circumstances here, where the allegation was initially an allegation of choking, and that was the allegation that was made in the PSI, even supported, even though I'm only sentencing you on an aggravated assault, the aggravated assault here in Ms. Osborne's articulation of how this crime has affected her convinces me that nothing else other than the maximum offense is appropriate. That's a rarity for me, but when I have a defendant who expresses no remorse, who doesn't appear for the PSI, who commits apparently new felony offenses in between the date of a felony misdemeanor plea and then a misdemeanor sentencing, I don't see any other options that's realistic. And so I will sentence you to the Crawford County Jail for the maximum that I have the power to do so, which is 1 year in the county jail. I recognize that sentence will have an effect on you. That's the hope that I have as well, that the sentence will have an effect on you, because one of the things I have to do is hope that I can deter future behavior. And if I have the ability to do so as a sentencing judge, that's what I intend, is to have an effect on your future behavior. To have you recognize that people who you in a loving, quote unquote, loving relationship with should not feel terrorized, threatened, or harassed by you before or after you choke them or hurt them. So it will be the order of the court that you're sentenced to the county jail for 1 year. You have no jail credit in this file because you were only lodged in a different file. I will strike all of the orders of probation because I'm not putting you on probation. I will order that you pay a $325 court cost, $50 state cost. You'll also be ordered to pay a crime victim assessment of $130. Those fines, costs, and assessments by state law are due today. Pay it within 56 days. A 20% late fee gets added on. Because I know you're going to be in the Crawford County Jail, as long as you pay within a reasonable time after you're released, I'll waive that late fee, but you otherwise will pay those fines and costs in full. You need to understand that you have the ability to ask the Court of Appeals for leave to appeal from this judgment and this sentence. If you wish to ask for leave to appeal, because this is a misdemeanor offense, you must make that request to the court in writing within the next 21 days. If you need a court-appointed attorney to assist you with that application for leave to appeal, you need to make that request to the court within the next 14 days. Mr. Prager, do you have anything further for today?
No, thank you.
Ms. Cope, do you have anything further for today?
Mr. McFalda indicated that the first 2 days were when he was originally arrested, he should get credit for, but the rest were for the new case.
Is that accurate?
Should be credit 2 days, sir.
From when his initial arrest was
4/21/25, 4/22.
Do you agree, Ms. Cope?
I don't have any information, so I would agree with Mr. McFalda.
Mr. Prager, do you have any reason to oppose that?
No objection.
I will provide that 2 days from your initial arrest, Mr. Stone. Spirit, I will provide it. Other than that, the court's order stands. And you remain in custody of the Sheriff's Department to serve your sentence. Court next calls the matter of people Brad Daniel Stone. This is file 25-18306FY.
Thank you, Your Honor. Richard Trish appearing on behalf of Mr. Stone. By way of arraignment, we would waive a formal reading of the complaint and stand mute to the charges. Mr. Stone intends to retain counsel, and we would exercise our right to an exam within 21 days.
All right, Mr. Stone, have you had a chance to read the complaint that's been filed in this matter?
Yes, I have, Your Honor.
Do you understand the charges and the maximum penalties?
Yes, I do, Your Honor.
Do you waive any further formal reading?
Stand mute, Your Honor.
The court will accept that and enter a not guilty plea on your behalf, Mr. Stone. You need to understand that you have several different rights, one of which is the right to remain silent and not have that silence used against you. Because of that, anything that you say on the open court record or in writing can be used against you later in court. You have a right to a preliminary examination, the focus of which is whether or not there is probable cause to believe that a felony was committed and that you committed it. You have a right to an attorney. If you could not afford an attorney, you could ask the court to screen you or have the MIDC screen you to have court-appointed counsel. But I will accept right now your intention to hire counsel. Is that your intention?
Yes, Your Honor.
So if you change your mind and or cannot afford an attorney, you should immediately notify the court so that the MIDC can be notified and you can be screened for the appointment of counsel. I will set your preliminary examination dates at the dates that are now available through Judge Burmeister's staff. As you know, I'm Judge Hunter, but these matters will continue first in front of Judge Burmeister. I'm going to set a felony pretrial on January 6th of 2026 at 1:00 p.m. And the next available date for preliminary examination right now is January 27th, 2026 at 2:00 p.m. If Judge Burmeister has additional dates, you can make those requests through your attorney and or through an appointed counsel if you can't hire an attorney in time, and he may be able to adjust those dates, but those are the dates that staff was to date able to provide to me. In terms of bond, Mr. Trush, I know that you were present today when Mr. Stone was sentenced, and he was sentenced by me on the other felony matter. It was a misdemeanor matter. It was a felony case number, but a misdemeanor matter. I sentenced him to 1 year in the county jail. I would suspect if you have awareness of that, you're not going to be asking me to set a bond that he can post in this case so that he can earn credit. Or he may not be able to earn credit because of the nature of the sentence that I just imposed, but what do you want me to do with regard to bond, Mr. Church?
Your Honor, that's accurate. I was present in court earlier. I talked to Mr. Stone about this. For today's purposes, we would just ask the court to set a bond. The amount I'm not necessarily concerned about. I did discuss with him if it becomes later in time that making a full bond argument is something that we need to do, we can do that. But I think given the circumstances, allowing his retained counsel or counsel down the road to make a more fully formed argument than I could today better serves his interests.
All right. And so, Mr. Stone, I want to make sure you understand what we're talking about here, because sometimes it's not as clear to non-attorneys as it is to the attorneys or the court. Once you're serving a valid sentence, you're not entitled to have any credit towards any other sentence. And so because you were sentenced this morning on a different matter, even though you're not going to be able to post bond on this matter, the case of People versus Givens stands for the notion that you cannot get credit towards a new file on this new one. You should cover that with your attorney, and if you have questions about it, he can file any motion in that regard. But I'm going to set a bond in this case, notwithstanding the fact that you're serving a 1-year jail sentence. I'm going to set a cash or surety bond in the amount of $10,000. It has several different bond conditions. You should read those. Make sure you understand them to the extent you ever post bond. And if you or your attorney in the future want to be heard regarding bond, I'll let either one of you file a motion so that either me or Judge Burmeister can reconsider those issues. Do you have any questions at this point, Mr. Stone?
I do not, Your Honor.
And I'll set those dates out for your benefit. I will make sure that you get a copy of those orders to appear as well as the bond. Mr. Trush, anything else today?
No, Your Honor, thank you.
All right, thank you. We're all set.